The financial process starts really with Form E and the completion of that very lengthy form, that 27-page form. And then you may engage in mediation, but if that isn't possible and you're heading to court, in most cases it's a 3-step process. So you're going to have the first appointment, and the purpose of that appointment is really for the court to assess the Forms E and to assess what is missing. Very often you may need valuation of property or valuation of business. You need further information about pension, and it will enable you to come back to the second hearing, which is a financial dispute resolution hearing. And the aim of that hearing is to look at the forms, to have your lawyers at hand, and to have a judge who will hopefully help the parties. And the judge can help by telling the parties what that judge would do, knowing what those assets are. So if the judge can see there's a property, there's savings, pension, the judge might say it should be split in a particular way to achieve housing for husband, housing for wife, children will be housed as well. So lots of cases do settle at the second hearing, the financial dispute resolution hearing. And if that doesn't work, then you'll move on to trial, which can be a very expensive process. Actually, the trial in particular, most of the costs are at trial. You can double your costs. So if you had a first and second hearing, and you double your cost and then you're at trial, because it could take place over a number of days. You may need some expert witnesses. The parties are going to give evidence. And you have an adjudication by the judge at that point. So up until then, you have some power to control your affairs and to have a dialogue and to settle. Once it goes to a judge, it's out of your hands. And in my experience, most people don't like the judge's adjudication because it doesn't meet their ends or their particular ambitions.